I hope you can all hear me. Good afternoon. Welcome to this webinar organized by the Mediterranean Migration and Asylum Policy Hub of the European Public Law Organization. My name is Marcos Karavias, and I'm the director of the Policy Hub. Today's webinar is dedicated to understanding the Italy-Albania Migration Arrangement Protocol, a move that has provoked a lot of discussions and a lot of legal actions, both in Albania and Italy. And I think it's very timely that we have this discussion and in the future also continue this discussion. As the example set by Italy and Albania is perceived, at least by the European Commission, to be some sort of an interesting experiment that we need to monitor. At the same time, we are in an environment of, let's say, political volatility, to put it very mildly, considering what has been going on the past days, where migration will play a key role. Very briefly, for us, what was important was to have this webinar, and the idea came along during a meeting we had in Bosnia and Herzegovina, where we realized that there's a certain interesting narrative, let's say, behind the Italy-Albania deal, a narrative in Italy and a narrative in Albania. And our belief and understanding is that you cannot shift policy without understanding the narratives. And this is part, I mean, the legal actions are part of the story, but there's also a whole policy discussion and narrative around it. So we have colleagues from Albania and Italy discussing the issue. And of course, in the next hours, we're going to go live with a policy brief on the matter prepared by two of our speakers, Hektor, Ruci, and Gemi. I would now like to pass the floor without further ado to Manos Moschopoulos, who will coordinate this discussion. Again, thank you for being with us. It's a pleasure, it's an honor, and I'm sure this is going to be a very interesting discussion. Manos, over to you.
Thank you, Marcos, and thanks to everyone that have joined us for this very timely discussion on this fast-paced politics and policy space that Marcos referred to, the Italy-Albania Protocol. We're very happy to be joined by the two authors of the upcoming MedMA report on the matter, Professor Gemi, the head of the Law Department at the University of New York in Tirana, and Hektor Ruci, a senior lecturer at the University of New York in Tirana. Joining them and offering the insight from the other side of the Adriatic, we have Professor Mario Savino, Professor of Administrative Law at the University of Tuscia in Italy. So welcome to everyone, welcome to all of our speakers, and I'm going to turn first to Professor Gemi for her thoughts and a preview, let's say, of what we're going to be reading in the report. The floor is yours.
First of all, thank you very much for having us, me and Hektor, on board. It was indeed a very great honor and pleasure to collaborate on this such, actual, let's say, topic not only related or linked to Albania, Italy and Albania, but also in a broader perspective, in a European perspective. So actually, I'm going to focus mostly on giving an overview what is happening on the ground, and then Professor Hektor will enter or will share with us more insights on the legal perspective from Albanian side. So under the Italy-Albanian Migration Protocol of November 3rd of 2023, ratified by the Albanian Parliament on February 22 of 2024, Italy funded the construction of 2 centers of permanence and repatriation on Albanian state-owned property located in North Albania, the northern port of Shëngjin, and the former military airport of Gjadër, which are 2, let's say, location sites that are temporarily allocated to the Italian government. These locations serve as facilities for the identification and accommodation of irregular migrants intercepted in international waters while attempting to reach Italian soil. Of course, this applies only to men migrants, while women and children are transferred are processed to Italy. So after their planned inauguration in May 2024 was delayed, the two migration centers established under the protocol commenced their operation on October 16. The first migrant transfer occurred on 16 of October, with 16 people on board of Italian Navy ship Libra. 4 of them, as we all know, were returned to Italy immediately. First, because 2 of them were minors, while other 2 for health reasons, with the rest also returning after the Court of Rome ruled that their detention was not valid, a decision that prompted Minister Giorgia Meloni to approve a new list of safe countries. And in another heavy blow, the Court of Catania did not validate the detention of 3 Egyptian and 2 Bangladeshi citizens who arrived from Albania to Pozzallo in South Italy. The head of Catania's court said that the list of safe countries drawn by the government on 21st of October does not stop the judiciary from fulfilling its obligation to verify the consistency of such move with European law. As we are speaking now, the same Navy ship, the Libra, carrying 8 migrants rescued Monday off Italy's Lampedusa land, has been disembarked at the port of Shenzhen. So new chapter, a renewed chapter of the same story. Now, going back to the protocol from Albanian perspective, although these 2 locations, 2 sites that I mentioned, remain part of Albanian sovereign territory, they will be temporarily used exclusively by Italian authorities as outlined in Article 3 and 13 of the protocol. On arrival at the centers, which operate under Italian jurisdiction, Italian officials will oversee the disembarkation and identification processes. It is estimated that between 3,000 and 36,000 individuals could be processed annually in these 2 sites. Asylum seekers and migrants will remain in Albania throughout the application process and possibly under their repatriation. Now, the Albanian police will ensure security and external surveillance for these facilities. Furthermore, the protocol includes several provisions stipulating that all expenses associated with this initiative will be borne by the Italian side, which will also cover any cost incurred by the Albanian side as a result of the protocol. On August 14, the UNHCR announced that while not involved in negotiations, it will serve as a monitoring role for the initial 3-period time period, after which it will provide its recommendation to the Italian government. According to the report of the law, on the Albanian law for ratification of the protocol between the government of Italy and the Republic of Albania, the protocol for ratification aims to enhance cooperation between the 2 governments, which, according to the legislator, is crucial for Albanian European Union aspiration. While indeed initiated by Italy, the protocol is significant for Albania as it addresses the management of irregular migration flows, an issue of mutual interest for the region. Furthermore, by engaging in this protocol, Albania seeks to reshape its image from a source of illegal migration to a proactive, let's say, actor in regional stability, promoting as such regular migration in line with international and European standards. According to the rationale of this law, this cooperation not only aids Italy, but also, according to Albanian legislator, contributes to the broader European efforts to manage migration challenges that have become increasingly, let's say, pressing in recent decades. Additionally, Albania's active involvement is seen as a testament to its role as a reliable ally to the EU, highlighting its unwavering commitment to European integration. While it is acknowledged that the protocol allows specific Italian authorities to exercise certain competencies within Albania, it, according to Albanian, again, legislator, It only mirrors other international agreements where countries grant rights to foreign bodies to manage specific matters on their territory. Putting it in a broader perspective, I would add to this discussion that the protocol may be viewed as a paradigm reflecting new political landscape in the EU, triggering concerns about, first, externalization of migration, with Italy's outsourcing or offshoring of asylum processing to manage migration outside its borders, while Albania viewing it as an opportunity to reshape its image from a source of illegal migration to a proactive actor in regional stability. Second, EU enlargement, with the protocol underscoring Italy's strategic role in Albania, reflecting, I would say, a neo-colonial approach. It seems that Italy seeks to bolster, or why not to revive, its colonial influence, coupled, of course, with other economic and cultural components in Albania, leveraging this partnership to offset concerns about Albania's democratic standards deficit and country's EU accession prospect. Third, human rights concerns, with the protocol raising significant concerns about the right to asylum by undermining established protections through extraterritorial management of asylum processes. Now, despite the Albanian's constitutional court's ruling on the agreement's constitutionality that Hektor is going to share more insights, unresolved issues remain, including the applicable jurisdiction, the standing of Albanian courts, and the efficiency of processing asylum claims. This is my initial overview of the situation on the ground from the Albanian perspective.
Thank you very much, Professor Gemi. And now we'll move on to Hektor Ruci.
Hello, everyone. It's an immense pleasure of being here and sharing some of these modest thoughts and insights over this treaty. Now, as Professor Eda said, I'm going to focus more on the constitutional and international law side of this agreement. The agreement which came as quite silently in the very beginning, and almost everybody knew about it when Rama and Meloni went to a press conference and declared the existence and the signature of it, which per se, of course, does not impede any illegalities, because this is sometimes normal, but nevertheless, the pledge of having these good relations and paying, according to the Prime Minister, a certain form of debt to Italy by Albania on what Italy has done on welcoming thousands of Albanian immigrants since the beginning of the 90s. When it comes to the legal concepts of the protocol, there are several issues here which inflict proposed illegalities to the Albanian constitutional system and beyond that. So in these 5 minutes, I'm going to focus on these topics. The first and most important is the way how the protocol was negotiated and signed, because the protocol within itself does include a certain concept of territorial applicability and integrity. And according to the Albanian constitution, protocols which do include this kind of issues, they should have a proxy. Those that negotiate and sign it should have a proxy by the head of the state, the President of the Republic, and that proxy was never given. The government, and together with the Constitutional Court, they sanctioned that this is not a question of territory, because according to the Albanian Constitutional Court, and I'm quoting, the protocol shall, the zones of the protocol, so Jadar and Shëngjin, shall be under double jurisdiction. According to the Constitutional Court, that meant that Albanian jurisdiction is not being excluded, despite the fact that all other circumstances tell us that only Italian and/EU or EU legislation shall be applied within that territory. Which means we have to deal here with a case of lack of sovereignty over the respective territory, because practically Albanian authorities do not have access to that territory. It is evident that the Albanian state or government has decided, by their free will, of course, to refrain from the ability of applying their rights into the two areas where the camps shall be deployed. In this regard, the protocol, as an act of international law concerning territory, as such, it has to fall under the stipulation of the Article 121, Fraction 1 of the Albanian Constitution, where a power of attorney should be given by the President of the Republic. And as we said, such a power of attorney is absent into that thing. The idea is that despite the fact that the Constitutional Court decided that, or specified that there will be a double jurisdiction over the island, of this piece of land, practically, from the moment that one jurisdiction is being applied upon the other, one should leave ground to the other. And by leaving ground shall mean that sovereignty will be less applicable, if we might borrow and use such a term. The other issue which goes around the protocol is the human rights issue. In its decision, the Albanian Constitutional Court explicitly mentioned that this agreement is not an agreement on human rights. But on the other side, every agreement of this kind does imply a lot of concepts regarding human rights. And in such human rights, right to a fair trial, as it is enshrined in the Albanian Constitution, as well as the European Convention on Human Rights. When it comes to that dimension of right, we might see that practically people leaving, which will leave in those territories, we haven't seen anyone yet passing more than 2 nights in there, 48 hours. That part of the applicability is based on the concept of distance. Well, the asylum seekers shall be quite in a distance from the respective Italian courts, which will deal with their cases. Also, they will bear different form of costs by being far away from that territory. Also, we have to deal with a concept which is an uncertainty of jurisdiction. And this uncertainty of jurisdiction has been pumped out exactly by the decision of the Albanian Constitutional Court, which has specified double jurisdiction over those pieces of land. So, indeed, what kind of legal assistance shall be given to these people? Which procedure shall be followed? Etc., etc. The other concept which is being applied is a concept of an obsolete legislation reference, because in order to pass this agreement, the two sides have been referring to the protocol of good friendship, to the Treaty of Good Friendship between Italy and Albania of 1995, which specifies that both countries, I'm quoting, the contracting parties agree to attach primary importance to close and energetic cooperation between the countries to regulate, in accordance with legislation in force, migratory movements. Now, all of us that lived through the 90s, we know pretty much well what migratory movements were meant in 95. Waves of Albanian illegal immigrants crossing the Adriatic by boats. So the purpose of this treaty was that the both authorities to work in stopping these illegal Albanians crossing to the other side of the Adriatic. It did not mean a third-party treatment over the agreement. Also, on the other side, the Constitutional Court, by its decision, it's working in an ultra-virus form. It's working in ultra-virus form because the Constitutional Court notes that, and I'm quoting, this means that the Italian state, which during the implementation of the Protocol on Migration will exercise its jurisdiction, is obliged to apply the international norms for the asylum seekers. Well, I keep saying it all the time. Since October 8, 1943, Albania and Italy are not together anymore. So the Albanian Constitutional Court cannot judge and pass its jurisdiction over the Italian side. There are also issues of Italian legislation regarding the 28 days of detention as it is provided by the Italian legislation. We do have a bulk of civil law implications here, which is regarding mainly buildings and structures. In other terms, who gave the permission? Practically no one gave the permission on building the barracks where these people will reside. Normally, according to the Albanian legislation, the authority which would give that permission would be the municipality of Leja. Well, believe me, nobody never whatsoever asked the municipality of Leja in building whatever was built there. So imagine what would happen if a balcony or a window will fall down during the stay of these poor people there. On the other side, I'm closing with it. According to the Albanian Constitution, Article 116, ratified international agreements, the law and normative acts are valid upon the entirety of the Albanian territory, which includes also, in principle, the validity of these acts in the territory and the application of those acts by Albanian public authorities. According to the pact, no Albanian public authorities shall enter the territory of the camps unless asked so by the Italian authorities, which will guard the camp. Albanian police is entitled to guard the external perimeter of the camp only. Thank you. I guess it's been 5 minutes.
Thank you very much, Hektor, Ruci. And now let's go across the Adriatic for the view from Italy. Professor Mario Savino, the floor is yours.
Many thanks for this invitation. Let me, first of all, make a reference to one of the distinguishing features of the protocol. Everybody has been very clearly introduced. There are many problems of jurisdiction, but let me stress one point that I find particularly relevant in understanding the specificities of this protocol. The element I want to refer to is the fact that Italy retains jurisdiction. That means responsibility over the asylum seekers brought in Albania. And this jurisdiction is functional to what? To carrying out the border procedure, the so-called border procedure, which is a specific, accelerated asylum procedure that is governed by EU and Italian law. This feature also involves an implication that is important: the application of both Italian and EU migration law to these procedures. This is written into the protocol in the Italian legislation of ratification. And therefore, what makes this protocol peculiar is two elements. First, the promise, just a promise. We will have to check it on the ground. The promise not to reduce the level of protection afforded to migrants by EU and Italian law, in principle. Secondly, there is no burden shifting, as it is usually implied by agreements on asylum offshorings, which we are more familiar with. For instance, the UK-Rwanda deal. In that case, you have migrants that are brought to another country, a third country, which takes exclusive jurisdiction or responsibility for them and their asylum applications. This is not the case according to the protocol we are discussing. Italy will be in charge, exclusively in charge. Now, let me turn to the main point of my first intervention, which is the relations between the protocol and the so-called new pact, EU pact on asylum and migration. As you all know, according to the new pact, the border procedure will become mandatory from 2026, June 2026. And this implies what? That some categories of asylum seekers will be subjected to detention during the asylum procedure, which is accelerated and will last up to 3 months. In Italy, currently, we have a border procedure which lasts 4 weeks, so much less, 1 month. So this is the premise in order to understand the Italian move, let's say, from the Italian perspective. So this border procedure will have to be implemented by all the member states. And in Italy, we are not prepared. Let's put it this way. In Italy, we are not prepared. And yet Italy will be the member state with the highest number of border procedures to be carried out annually under the new pact starting from 2026. 16,000 border procedure from 12 June 2026, 24,000 in the following year. Why is this relevant? Because numbers matter. In Italy, we have a very weak system of detention centers, which are meant, their purpose is to repatriate migrants currently, right? Because we introduced the border procedure 1 year ago, but de facto it has not been yet implemented. So the few detention centers we have have this specific purpose of allowing repatriation. And guess what? We have only 800 places in those centers. So we will not be able to meet the threshold set by the European Commission in August this summer. 16,000 from 2026 annually, and 24,000 border procedure from the following year. So the strategy of the Italian government was, first, let's introduce the border procedure in order to see whether it can work. And we did it with law number 50 of May 2023. And so far, it has not yet been implemented because of the approach, the judicial approach we predominantly had in Italy, and I can address the topic later. But let me focus on the other part of the move, which was the protocol with Albania. In order to remedy the shortage of detention infrastructures in the Italian territory, we're looking for the possibility to have new detention facilities abroad in Albania. And these facilities should reach a capacity of 3,000 places, which, if used efficiently, 1 month is the current duration, maximum duration of the border procedure according to Italian legislation. 1 month, if you multiply it for 12, it means up to 36,000 if we manage it very efficiently. On average, we can say 15,000, okay, when we will have the full capacity reached, which means Italy would be able to meet most of the demands that come from the European Union. There are some obstacles, many obstacles. One is the approach, the judicial approach that is predominantly adopted by Italian lower courts, which are in charge for validating the detention orders. And the other is the strictly territorial approach by EU law. We said EU law will be applied, but according to the protocol, not to EU law itself. According to the current rules under the Common European Asylum System, due to their strictly territorial approach, this protocol is as if it is not existent at all. So one big question is whether the detentions carried out by Italy extraterritorially in Albania, whether they will be actually counted under the Common European Asylum System. I'll stop there for the moment. Thank you.
Thank you very much, Professor Savino. And a reminder to everyone that's listening that you can submit your questions through the chat function in Zoom. So look for the button and I will receive the questions together with all the panelists, and then we'll try to get through as many as we can because we have quite a few attendees with us today. To kick things off, I'm going to reverse the order that we've heard. So I'm going to start with a question for Professor Savino, right? And you gave us quite a bit on how this interacts with Italian EU law and all the implications of the protocol. And I was wondering, what has been the reaction so far within Italy to the protocol and the attempts to implement it?
Well, as you all know, the 12 migrants that were brought to Albania were taken back to Italy because the Court of Rome has denied validation of their detention orders. And it did so by scrutinizing the notion of safe third country. Those migrants were coming from Bangladesh and Egypt. And the Court of Rome established that those two countries cannot be designated, not just considered, but designated by the government, should have not been designated by the government as safe. Why is that? We have to take a step back. On the 4th of October, so 1 month ago, the Court of Justice ruled that with regard to a case concerning the Czech Republic, not Italy, that courts, national courts, can review the legality of the designation of safe third countries when a part of the territory of those third countries are not to be considered safe. So there are territorial exceptions that, according to the previous directive, 2005, I'm referring to the directive on procedures, on asylum procedures, those exceptions were compatible with the designation of the state as safe. Now, according to the current directive, which does not mention territorial exceptions, the court established that it is not compatible anymore, which means if there is one part of the territory that is not safe, the whole country cannot be included in the list of safe third countries. And this is important because in order to apply the border procedure, you have to establish whether the asylum seeker concerned is coming from a safe third country. So those guys, those migrants that were coming from Egypt and Bangladesh were not to be considered as coming from a safe third country because of the fact that the Court of Rome established that the designation of those countries as safe was not legal according to EU law. Let me stress one important point though. They did so with regard to two countries where there is no territorial exception. There is rather a personal exception. The Court of Rome said, even if the whole territory can be considered safe, there are still some categories of persons that in those countries, like LGBT, political opponents, etc., that cannot be considered as sufficiently protected. And therefore, we extend the ruling, the principle established by the ECJ, the European Court of Justice, on the 4th of October, from territorial to personal exceptions. And we derive from that the inconsistency, the illegality of the designation of a safe third country, also of those countries which do not sufficiently protect some minorities or other specific categories of persons, which is a bit of an overstretch, of course. And therefore, a lot of discussion arose in Italy. The government claimed that courts are taking political decisions, adopted a new legislation on the list of safe countries, which was included now, is covered now explicitly by law. It was an administrative decree before. But I don't think this will change much because Italian courts will still disapply or not apply that list because they will keep considering it inconsistent, in contrast with EU law. The final trend by Italian courts is that in the past few days, several courts are proposing questions to the European Court of Justice in order to clarify whether it is correct and consistent with EU law to assume that a safe third country cannot be considered as safe when there are not territorial but personal exceptions. I'm sorry, it's a bit technical, but I hope it was sufficiently clear.
Very clear and very informative, Professor Savino, thank you. And I'll go back to the view from Albania and Hektor. Professor Savino mentioned how this is, in a way, how this interacts with Italy's detention system and the lack of capacity, etc. And I was wondering, how do these Italian-administered camps look like compared to the existing Albanian refugee system? And do you see this practice having an impact on how Albania handles asylum from now on?
Well, the answer is kind of easy, Mano. Whenever you want to buy a car, you do a test drive. Well, we had no time for test drive because those that came, as they came, they left. So the practical capacities and circumstances in the camps are unknown to us. On the other side, Albania does not have such large requests on asylum as Italy does. Therefore, to find a comparison between the two, if Albania will gain anything from this experience, well, I don't know. First, we have to try the car, and we'll see what happens with these 8 that arrive now, and the other 2,992 that are expected to arrive, because the capacity will be 3,000, and then to check it. We haven't had major issues with these camps in Albania. We had a comparatively large number of Afghan immigrants after the fall of Kabul, which were hosted in hotels at the Albanian seaside, and conditions there were pretty much acceptable. But we're not talking of the same thing. So comparison, it's kind of hard now. We have to wait and see how these camps will perform practically. They haven't been practically collaudated yet.
Indeed. And I did read in the press today that hotels are now being used to accommodate the Italian officers. And of course, I don't know if it's the same hotels that you just mentioned.
Well, we have a history here, because when Italian troops entered Đakovo in Kosovo after the end of the bombardments, their first interest was to go and capture the main and only remaining hotel of the city to lodge themselves. So
accommodation is an important consideration. Well, Professor Gemi,
absolutely.
Coming to you, because we've heard quite a bit about this dual jurisdiction, and one question that's on a lot of people's minds, including some of our attendees here, is what happens if asylum seekers are in Albania at that point and decide, you know what, we want to stay here, want to claim protection here? What could that possibly look like, given that, of course, we don't know exactly how this will be implemented or anything, right? But what are your thoughts?
So first of all, there are some very unclear points in this entire, let's say, not only protocol in terms of the paper, I mean the document, but also some other technicalities that we are not aware, at least I'm not aware of. For instance, what about repatriation? Who is in charge? Who is responsible? I mean, based on protocol, it seems, it appears that Italy is the one that, I mean, is responsible for the repatriation. The question is if there are readmission agreements in place that could facilitate whatever repatriation, if Albania is going to share this responsibility of repatriation of these people, still Albania is very, let's say, at infant stage when it comes to its system of asylum, as my colleague Hektor very eloquently and with a lot of jokes described, actually. So my point of concerns are, first of all, the problem of cost effectiveness, which was again mentioned, but still I cannot see the rationale behind, I mean the rationale of rationality behind creating such an, let's say, a precedent in offshoring migration control, migration, let's say, management. Why? Because we know very well that we're talking about people that if they're, let's say, the rejection of their asylum, whatever, they are subject to repatriation, to detention, to, I mean, deportation. Actually, you know very well that from the camp till the port, from the camp during the, let's say, the journey from the camp to airport, for instance, they have any right to claim asylum on Albanian soil. So there are no, let's say, indicators or no elements or whatever description what is going to take place if this is going to be the case. First. Second, there are other concerns about what is happening in the region. The migration, I mean, the Balkan corridor is still in place. This is a reference to the migration, to the refugee crisis, I mean, in 2015, 2016. So actually, there are a lot of, let's say, illegal channels for people that probably are their asylum application is rejected to make use of those very willing and profitable smuggling ring in this actually area. And on the other hand, it's interesting to see how Albanian government is going to, let's say, to benefit in terms of mechanisms to improve or to upgrade its own asylum system. Why? Because we know very well that Albania actually is a country of mixed migration flows. We have a large number of people leaving Albania, mostly highly skilled Albanian citizens leaving Albania for better opportunities, especially in Western Europe. We have, let's say, migrants usually recruited because of the labor shortages in Albania to work in different, let's say, construction sites. On the other hand, we have this, let's say, new experience of accommodating asylum seekers. It was mentioned before, the case of Afghan, which is not a classical case of, I mean, asylum seekers, because they are actually treated as, let's say, tourists in a way. Or we have the case of Mujahideen, again, as a favor to the United States, that are actually still in Albania. I mean, they are accommodated as hosted here. So it's a, let's say, entire chain of components, elements that are very interesting. Indeed, it's a laboratory that we would see how this, let's say, endeavor, or that this, let's say, story is going to take place, actually, to be evolved in a way. But still, I think it's, I don't see any, again, rationality in this new test. I only see what, I mean, those kind of small alliances, these romantic relationships, bilaterally decide, like, for instance, Rama Meloni, they love each other. I don't know, we are doing only for Italy because Italy is in our hearts. No one, I'm not going to do it for other countries. Those are the, let's say, the recent declaration statements of Rama.
Okay, thanks a lot. And there's already a lively chat going on in our Q&A section, which would be somewhere here on your screen. So join in and add your own questions as well, and our speakers can engage with them as we go. And of course, we'll try to answer as many as we can here. And I see already, Professor Savino, you have engaged with a question on whether or not Italy can evade implementing EU law, and the question of how the screening procedure within the pact impacts with the extraterritoriality of this. And I was wondering, based on that also, normally you would have Italian lawyers, Italian advocates that would be able to respond to the needs and the protection and rights of migrants within facilities like this one. And given the extraterritoriality here, given the situation that you described, what is the role for these lawyers, these advocates? How can they perform it? And if you want to reflect further on the question you've already touched upon.
Okay, let me start from the question that I received from Vasileios. The problem of evading the screening procedures and actually all the other limits that EU law puts on first member states of entry. Let me remind that there is a general principle in EU law according to which first member states of entry cannot evade their obligation to process the asylum application within their territories. So how do they evade these obligations under EU law? By making the whole operation extraterritorial. I wrote in the chat. What does it mean? If you look at, not so much perhaps in the protocol, it's not very clear in the protocol, but it was made very clear in the Italian legislation of ratification. It clarifies that Italian authorities can only bring to Albania migrants who were rescued on the high seas, international waters. And this was a specific request, I ascertained, from the European Commission, which asked Italy to avoid any specific link with the Italian territory. And therefore, Italy cannot take to Albania people who have been rescued and disembarked in the Italian territorial waters or in Lampedusa. They can only take there people who are rescued on the high seas. By making this, I mean, with this limitation, Italy is free to process those asylum requests and examine the positions, the individual position of each asylum seeker according to the protocol. EU law does not apply as a consequence of an EU law provision, but as a consequence of the protocol. It's a unilateral, from the part of Italy, it's a unilateral decision to apply EU law. But let me repeat this. From the perspective of Brussels, EU law itself does not automatically apply to this case. On the problem of the right of defense and the role of lawyers, how do they protect migrants' rights when they are disembarked in Albania? Again, in the Italian legislation of ratification, there is a very limited provision, a very narrow provision, which only says that the procedure will be carried out online, and therefore the migrant will be interviewed online by the administration and later on by courts. Lawyers will do the same unless they want to go physically in Albania, and in that case they can get a refund of 500 euros. It's the maximum amount they can get. Apart from the fact that all these, you know, it's quite insufficient to clarify all the aspects that make the right of defense effective. The problem is, for instance, who is going to inform the migrant of the possibility to defend itself or designate a lawyer to protect his own right? Who will provide the list of actual lawyers ready to be there? These things are not clear at all. To be sure, we don't know yet because the first 12 cases were defined in a very preliminary stage when the court were asked to validate the detention order, which is an automatic decision. So migrants that arrived there did not have to experience the problem of finding a lawyer that was to protect their rights. So far, we don't have a sufficient answer to that.
Thank you very much. I don't know, Hektor, would you like to add to what Professor Savino just said?
Absolutely. Thank you very much. Well, Professor Savino said pretty much all. The idea is very simple because from one side we have all the legalities and procedures, and from the other side we have the practical implementation. So, and we have witnessed that during those 2 days, that those 16, 14, 12 that remained here, even the Albanian ombudsman was not allowed the first day to enter the camp. which would create a serious problem when it comes to accessing justice and accessing justice systems. Of course, because of that test drive history, we didn't have the witnessing of what would have happened the second or the third day when the appropriate decisions would be made. But still, this is a grave alarm bell which rings upon everyone upon the applicability of human rights and the access to justice into those camps. And second, when it comes to the process of transporting, not deporting them, I saw several questions on that. Well, that is done by Albanian buses, Albanian drivers, Italian police, and one Albanian police car which opens the road for traffic purposes. On the other side, at any given moment, whoever of those people, at any instant, in going or coming from the camp, mainly coming from the camp, will be deported back, it can plead and ask for asylum in Albania. And in that case, Albanian authorities are obliged to accept his demand and start scrutinizing it. So it's not that extraterritorial as had been processed. Also, at the moment of entrance, both of them shall be checked by Italian and Albanian police because they're entering Albanian territory. And we have the obligation, at least based on the decision of the Constitutional Court, of double jurisdiction. And here comes another form of how it has been applied, because what Professor Gemi said, this is a story, you know what, this is a story in which two prime ministers have done in the heat of their love, somewhere in summer in Albania. And now when things go more quiet and we enter into the implementation, we see at least Prime Minister Rama, which says that, you know what, this is an issue of the Italians, this is Italian jurisdiction, Italian legislation. I don't know what's going on there. We have delegated everything to Italy. We won't take a cent of euro back, because if we take a cent of euro back, then it's not us anymore. So there are a lot of interrogatory points in the interrogation points in the whole story.
Thank you very much. And staying within the situation in Albania, there's a couple of questions in the Q&A, Professor Gemi, that refer to sovereignty and Albania's obligations, and whether or not Albania is able to avoid its obligations or jurisprudence. And you've already mentioned, you and Hektor Ruci, how you see echoes of colonialism, let's say, in what's happening. And I'm wondering, how is Albanian society and civil society reacting to what people from the outside in the Q&A and of course beyond the confines of this webinar see as either an evasion of responsibility or by Italy or Albania? So how has it played out so far in your community?
First of all, in order to understand, the atmosphere, the nuances of the reaction coming from the civil society, but also from local society in a way, we have to keep in mind, seriously, the one-man show of our, let's say, prime minister, which means that Albania, actually, we have one, let's say, Shakespearean actor who actually is, taking whatever he thinks that could help or could pave the way for Albania to become member of European big family, actually. So in order to understand, as I mentioned, this soft, let's say, interpretation of the situation in Albania, we have to keep in mind this model of leadership. We are a very small country with a very, let's say, problematic past with 50 years dictatorship. So actually, when it comes to, let's say, the reaction or the answer from the civil society, there is only one open letter signed from I think 19 or 20 NGOs in Albania that are ringing the bell about the question of human rights. And why? Because taking, let's say, or having this precedent of delaying in processing asylum files, according to their letter, is impossible for Italian, let's say, system to process asylum claims in 28 days, which means that we're going to have a longer stay creating more problems in terms of securing and safeguarding decent, let's say, conditions of those people in those centers. So there is a reaction. It's very vague in a way. It's not, very much articulated in terms of making serious claims, apart from what our opposition party did when actually filed or sent the case into the Constitutional Court, as we have already discussed. But on the other hand, from the local community, at least as it's portrayed in the media, they are very happy because actually their local economy is going to, in a way, to flourish. Why? Because there are many Italian, highly paid bureaucrats, technocrats, whoever, whatever, which means that the economy is going probably to benefit or from this, let's say, new situation, especially in this very poor region of North Albania. In a way, this is the situation in place. There are voices, of course, but there are single voices that actually are trying to make their claims heard, but it's very difficult in a country like Albania. And on the other hand, it's interesting because what Hektor said about this, let's say, double or dichotomical approach, there is or there is not double jurisdiction based only on protocol, not on, let's say, the ruling of our constitutional court, Hektor. Because if you, let's say, read or listen what Rama says, for instance, I have nothing to say because everything is, as it was mentioned, delegated to Italy. I have any concern or any issue to deal with. So I don't know if this double jurisdiction is actually understood from our Prime Minister, Hektor. No, okay.
No, apparently, if I may, right? Apparently is not, because his declarations continue to be in the part that this is part of Italian jurisdiction, Italians will take care of it, Italy, etc., which means practically that either Prime Minister has not read the decision of the Constitutional Court or he does not to refer to it. Or in his mindset, he settled something which, as you rightfully said, is based on the protocol, because the protocol on itself mentions only Italian jurisdiction. And my humble opinion is that the Constitutional Court, in a 5-4 voting, it inserted the part of the double jurisdiction in order to avoid the implementation of Article 121, paragraph 1 of the Albanian Constitution, which wanted the proxy of the President of the Republic, which was missing anyway. So it was a form of justifying a posteriori something that had already happened, and that was considered as I don't know, somebody which suffers from high radiation, and you give to that person aspirin. That's it how it gets.
I think that's a very interesting kind of reality from the ground, and it's triggered one of the responses in the Q&A from one of our attendees, that how this also looks like we're talking about derogations from the rule of law in order to facilitate EU accession, and how that would be ironic, let's say, in kind of Alanis Morissette terms. But going back to the questions that we're receiving, and there's quite a few of them, and of course keep them coming, and our speakers are also trying to address as much as they can while typing. And going to Annalisa's question, Professor Savino, that detention is supposed to be an ultima ratio, like it's supposed to be the last resort, and now it becomes literally the first thing you do the moment you're done with the triage on the boat. And first of all, like, how strong is the legal protection that this would be a last resort by now? And, how can Italy comply with whatever obligation it has vis-a-vis not detaining people arbitrarily?
Okay, this is an important question. Let me clarify two aspects. First of all, since Italy retains jurisdiction and the Albanian centers are meant only to carry out the border procedure, what happens later will happen on the Italian territory. Okay, or even if the border procedure cannot take place, as it happened last week, people will be returned to Italy, actually transferred to Italy, because they never set foot in Italy before. As I said, they were rescued on international waters. So this is the first important question. Second element. Italy obliged itself to apply Italian and European Union law. So the rules we, as Italian authorities, implement are the same rules applied in the Italian territory. And this applies in particular to the border procedure. According to the border procedure, asylum seekers can be detained, first, if they come from a safe third country. Second, if they do not have a passport showing their identity with clarity. Third, if they cannot constitute the so-called financial guarantee. Okay, so if they have an amount, sufficient amount of money, and they can constitute it with quite a complex procedure, they can avoid detention. These are the alternative. Technically speaking, having a passport and constituting these financial guarantees are the two alternatives to detention according to the Italian legislation. They are applied exactly the same way in the Italian territory and in Albania. You may wonder, well, but what if people arrive in Albania and show a passport or claim that they are able to constitute a financial guarantee? They will be taken back to Italy. So this is the way the alternatives to detention will be applied, basically. This is an important element, but you have to consider the whole system as a system that is based on this, on a fiction of continuity between the border zone in Albania and the rest of the Italian territory. Let me also add one thing, though. Bearing this in mind, one may wonder whether the whole system will deter migrants. This was addressed in the answer by Hektor, in one of the answers by Hektor to one of the questions. I mean, the Italian government claims that this protocol will have a deterrent, an effect of deterrence. It will deter migrants from engaging in migration towards Italy by boat, because they know that they might end up in Albania and therefore outside the Schengen area. But I don't see it. And I don't see it not only because, as Hektor said, they might not know. Numbers will count. Even if Italy will be able to manage efficiently the 3,000 places that they have in Albania, and let's say they make 30,000 detentions per year, which is huge number compared to, I don't think so, but let's take it for granted. In Italy, we have every year more than 100,000 people arriving. So those who are going to depart will still hope to be among the 70–80% of the people that will manage to actually reach the Italian shores rather than Albania.
Thank you, Professor Savino. I believe Professor Gemi has a question for you, so I'll pass the floor to her.
Professor Mario, just, question or clarification about who is going to be responsible for the deportation, if there is any clause in place that can give us whatever clue that Albanian or Italy or both, or in what are the technicalities in a way. First, and second, what's the reaction, I mean, after the first, let's say, the first disaster in a way, or the first failed attempts to send irregular migrants to Albania? What is the reaction of public opinion in Italy? Because the cost, as you know, was huge. It is estimated that €28,000 was, let's say, the cost of transferring those people from Mediterranean to these camps in Albania? Thank you.
Okay, let me start from the last question. So the outcome was very briefly put polarization. And since it became a highly political issue, we had a major division in the public opinion. On the one hand, those who were saying we do not believe this is an appropriate way to manage migrants, that are pointing to the costs that this protocol involves, and say, look, this is a waste of money. We are spending a lot of citizens' money over, maintaining police forces there with empty centers, and that's not the way to manage financial resources, public financial resources. On the other hand, we have a part of the public opinion that says we're not sure that courts should step in the way they're doing it. Because, for instance, who is in charge for establishing that in general, not with regard to the specific situation of the asylum seeker, who says that it is up to the court, to the lowest courts actually of the Italian system, to decide whether Morocco or Egypt are safe? Imagine that those are the same countries with whom the Italian government is going to establish agreements for readmission. So on the other part, Moroccan authorities might say, you want to readmit my citizens in my country, but your courts are saying I'm not a safe country. Do you see the contradiction? So there is a huge debate going on this issue. I forgot the first question. I'm sorry.
Deportation. Who's going to be responsible for if the
right. Italian authorities, and the question is from where actually they will deport people, and the answer is Italy. So what will happen in principle, according to the Italian project, is we take people on the ICs, we brought them to the first center in Albania where there is the screening. Then if there are some vulnerabilities, those people are already immediately taken back to Italy. The rest stays longer for the duration of the border procedure, currently 1 month, 28 days. After that, in those 28 days, each single asylum seeker gets the administrative decision and the judicial decision, should get. If we manage to do that, and the outcome is a denial of protection, then those denied asylum seekers should be repatriated immediately. And the idea is to bring them back to Italy and organize the return from there. Basically, from Bari or Brindisi, they will immediately put on a plane. This is in theory. In practice, there is a huge problem. Again, Italy has only one actually fully working readmission agreement, the one with Tunisia. So this means that either Italy takes to Albania only Tunisians, or they will take only small numbers of people from Egypt and other countries which have already accepted to take them back because these are little numbers. But overall, the other readmission agreements we have work with 50 people per month. So big numbers cannot be accommodated with this project. And this will mean that if Italy takes systematically Nigerians, Gambians, etc., to Albania, they will stay there 1 month. Then they will go back to Italy for the return. That will never happen. So they basically will be, again, free to move in the Schengen area, which is basically a failure, quite evidently.
Thank you, Professor Savino. And indeed, there was speculation in the Italian press over the weekend that the next batches of migrants to be put on boats would be Tunisians, both for the readmission agreement and the relative ease with which Tunisia could be declared safe versus other places. We're coming close to the end. We have some questions with regards to the situation in Albania. And Hektor, I already see that you have referred to what the opposition parties have done in Albania, which is to send the case to the Constitutional Court. And there's another question that's very important, which is how do people have access to healthcare? What if hospitalization would be needed if people are in one of the two camps, at which point they would have to be transferred to a hospital nominally under the jurisdiction of only Albania, one would imagine. Would that be irregular entry? Would that trigger other state procedures? Has anyone thought about this?
Well, no, to some extent, actually, because on the pact on Article 6 or Article 4, actually, it is specified that in case of health emergencies to which Italian authorities cannot cope with, within the facilities, as in paragraph 1, because in paragraph 1 tells that this facility will be under Italian health coverage, the Albanian authorities will cooperate with the responsible Italian authorities to ensure the necessary medical treatments to the benefit of the migrants held in the facilities. And then paragraph 9 goes to the costs, which of course goes to the Italian government. So it is not clear, as you can see it from the content. It was just a quick translation I did right now, so maybe it's not 100% accurate, but normally they will be treated according to Albanian hospitalization rules. Costs will be covered by the Italian side. As a matter of fact, when they enter Albania, that's what I mentioned before, they will have these double registrations. They'll be registered by the Italian authorities and also by the Albanian authorities. And the protocol several times mentions immigrants which will be set in Albania. So they are not illegals in Albania. Come on, let's make this clear. Then, to what extent they will have these facilities? It's a very strange position. I think practically nobody thought of it. This is enough ground for one of these asylum seekers. Once he receives a negative answer from Italy, he will faint, and then they will take him to a hospital, and they'll feel a request, a claim to have asylum in Albania, and therefore push its residence in Europe for some more years, till the Albanian authorities will check his application.
Many thanks, Hektor, and we're coming to the end of our webinar, and I would like to thank our speakers, Professor Gemi, Professor Savino, Hektor Ruci, for illuminating us with regards to the state of play with the protocol, where we are, how we imagine it would be implemented, and where do we go from here. And of course, the perspectives from the ground from the two countries are very important for all of us that are trying to understand it from outside Italy and Albania, and try to imagine questions like, how does this interact with the pact? How does this interact with the incoming European Commission? What does it mean for the plans and ambitions of other countries that are looking at this and saying, oh, this is very innovative? A lot to be seen still, given that, for all we know, 8 migrants were transferred to this facility yesterday, and we are waiting to hear more about whether or not they will be accommodated in that space, or whether or not they would be transferred back to Italy, like the previous 16 migrants that were attempted to be transferred to that space. Before we go, I will pass the floor back to Marcus Carvey as the director of the Mediterranean Migration and Asylum Policy Hub, that has more details about where you can find the report that Professor Gemi and Hektor Ruci have prepared, and how you can keep in touch to give us even more questions after you've read the report. Marco, the floor is yours.
Thank you, Mano. I would like to thank the speakers for this extremely interesting discussion. I decided not to make use of any sort of privilege, intervene or ask questions, although so much was going through my head. 2 very brief comments. There was a negotiation on the pact, a very lengthy negotiation, and the moment it was adopted, a group of states decided to circulate, or at least prior to the adoption, there was a discussion on innovative solutions, which I think is very ironic, casting shade on the fact that it's not innovative enough. And the innovation is externalization, which tells you a lot about, what makes asylum policy people think is innovative. And the second point, on the point about extraterritorial application of the pact, if the long game of Italy is to extraterritorially count towards adequate capacity by using the detention places in Albania, but at the same time not be liable for violations of the pact because of its territorial reach, I have to admit this is ingenious, problematic, but ingenious. But it raises many questions. Dublin rules, I mean, when you reach adequate capacity, there are some perks for states and so on and so forth. But this is for the next discussion. From my side, thank you very much to the speakers. It was extremely interesting. Thank you, Edda, Hektor, Mario. Lighting, casting light on law and policy and narrative. Thank you to all the attendees and your questions. I hope this was as illuminating as it was for us. As I said in the beginning, in the next hours, we will be going live with the report prepared by Hektor and Edda. We will be uploading it on our website and also making announcing it on our LinkedIn page. So if you don't follow us on LinkedIn, please do so. And definitely, I hope that we will continue this discussion, because there is a lot that I think will be coming up also with the new commission. This innovative thinking is not going away anytime soon. So with this in mind, thank you all very much, and I hope to see you in the next event. Bye-bye.